and whether those who are traditionally skeptical of vague statutes, even on the more conservative side of the spectrum, might let down their concerns in the context of terrorism. I mean, so that's part of why the atmospherics here are so, I think, tricky and difficult to project.
Okay, I see we do now have a line at the microphone. So again, reminders to please identify yourself and to please actually ask a question.
Thanks, Sharon. I'm Karen Grizz. I'm at the Fried Frank Law Firm here in Washington, D.C. Shane alluded a little bit to the material support context in the material support concept in the asylum and inadmissibility context, and I wanted to ask, given that the outcome of the case that you're talking about is far from certain, I wondered if you could make any comments on whether the decision, regardless of what it may be, squarely in the criminal context, would have an impact on the material support provisions with regard to asylum eligibility or admissibility generally.
Yeah, I'm not completely up on the wording of the immigration provisions, but I suppose it's possible that would have an effect, especially if the intent requirement is something the Supreme Court brings into play here.
Actually, if I remember right, it does specifically refer to material support as defined by 2339A. And so, I mean, part of the problem is that since 1994, as Congress has grown increasingly happy with the idea of material support, it has continually cross-referenced back to the original definition. So this shows up in several contexts, one of which is immigration law, one of which is civilian criminal law. In unrelated, but I think not completely irrelevant context, is also military commissions. And so I just, there could be, and I don't think it's easy or desirable to speculate as to what the implications could be, but this will show up in all of those contexts. And that's why I think that, even though the specific activities that these plaintiff groups want to conduct can be very narrowly described and tightly confined, that's why this case could have very sweeping implications if the court does decide it broadly.
Yeah, although, in the Commission's context, I think, this case is probably unlikely to have a direct impact because the government itself said, I believe in March in its briefs, that you had to be substantially supporting al-Qaeda or Taliban or a group associated with them, and that meant that it didn't include things like insignificant or unknowing support. So there you're really, looking at, another, context that the government says is crucial to our national security efforts post 9/11, who can we detain under the authorization to use military force, but they're requiring things that are much closer to what we would traditionally require in the sort of conspiracy context, Again, intent to further the ends, the unlawful ends of the conspiracy, agreement to further those ends. Not this sort of material support situation where if you provide one tiny bit of fungible services or $1 that's fungible, then you're liable, essentially for, every sort of illegal act that the group says. Courts in the military commission context have said that you've got to kind of stand in the command hierarchy. So again, that's closer to the traditional principles, of conspiracy law, and we survived, pretty well as a society before there was a material support statute.
I agree with that.
Enforcing those, using those principles to go after the same sorts of targets that the government thinks are at the core of who they want to use this material support statute against.
Okay, next question.
Hi, my name is Sahar Aziz. I'm here with the Bill of Rights Defense Committee. I had a question. I wanted to flush out kind of what Stephen had said and had a follow-up question with regard to the avoidance doctrine. So if the Supreme Court does decide to avoid the constitutional issues and rule more narrowly, what are the factors that weigh against just adopting the specific intent requirement? I think from a layperson's perspective, it may seem to be kind of the simplest answer to just, okay, you need a specific intent, and therefore we don't have to deal with the constitutional questions. And I'm just curious to know what are the factors that are for and against it, aside from the political issues?
Just purely legally, and I say this not because I agree with this argument, but just to describe it. I think I think the government's argument would be and has been that Congress's deliberate choice in 2004 to incorporate a knowing standard as opposed to a specific intent standard is really the driving consideration, right? That the instances in which the court has grafted a specific intent requirement onto criminal statutes are usually cases where the statute says nothing about the relevant mens rea. And I think, the notion that Congress specifically thought about the mens rea, provided it would be one thing, that the court would instead adopt another as a saving construction is going to be hard to square for those justices who, are really quite closely tied to the letter of the statute. That's not to say they can't do it. I mean, in constitutional avoidance cases, the court has done far more violence to statutes than that. But I think that would be the countervailing argument.
From a policy standpoint, obviously the government loves having the flexibility of charging anybody without, when there isn't sort of something apparent on the surface of the facts that would indicate sort of malevolent intent. I mean, there's a case going on right now in New York City where a kid's been in solitary confinement for 2.5 years awaiting trial on charges that he essentially loaned to a serial informer the use of his couch in London and stored some luggage for him that contained waterproof socks and ponchos, and let him use his cell phone, and that informer, who's testified in 7 or 9 cases or something like that, turned out to have, sent those socks and ponchos on to the Al-Qaeda or the Taliban off in Afghanistan. So, the intent doesn't sort of jump out at you from the facts, and, but of course the government probably wants, to sort of be able to, have maximum leverage to extract a plea or cooperation or find out, information about other people that this kid may know. So, it's, again, I point to that low conviction rate, which the government highlighted in its brief, really, 75 out of 150 cases. It's kind of astonishing, and it tells you something about how it's being used.
Is another question at the microphone there?
Hi, my name is Michelle Morris. I'm a student at Gallaudet University. My question is in regards to your website. It discusses there's no statutory limit currently on the executive designation to designated groups. And I'm wondering how that might be addressed in this case.
Well, so I mean, Shane mentioned this before, and I think it's worth emphasizing that one of the hard questions that arises in the context of the material support statute is whether a criminal defendant may collaterally attack the designation of an FTO, right? Whether you may challenge your indictment for providing material support by saying that the group that was an FTO actually should not have been designated as an FTO. There's case law on this, and the case law says no, that you cannot, in a criminal case, collaterally challenge the designation process, that in fact the only real remedy is for the group itself to challenge the Secretary of State's determination, I think in the DC Circuit is the way the law is set up. And if you want to sort of read more about this, there's actually a very angry dissent by Judge Kaczynski in a case from 2005 called United States versus Afshari, AFSHARI, where he explains why this raises a whole host of separate problems. That's not an issue here because to my knowledge, neither the PKK nor the Tamil Tigers have sought in this litigation, or the plaintiffs haven't sought to challenge their validity, the validity of their designation. But there's at least case law that seems to suggest that the criminal defendants cannot raise this argument, only the organizations can.
Right, and the organizations are extremely limited. There are 3 elements to designation as an FTO. A group's got to be foreign, it's got to essentially kind of engage in violence, terrorism, and that its activities have to threaten the national security of the United States, including our economic interests, so it has to be threatening, essentially. That last one has been held to be unjusticiable, meaning that courts can't really look at what the executive has done there. It's an area of kind of complete deference, essentially, the courts of appeals have said. So, you really don't get much very significant if you're a group seeking to challenge your designation. Beyond that, there's a second scheme, which Lisa had mentioned, that creates SDGTs, specially designated global terrorists. This was set up by executive order after 9/11. President Bush declared a national emergency under IEPA, the International Emergency Economic Powers Act, and designated the Taliban and a bunch of other groups, I think, at that point, and that list has suddenly grown, or has since then has grown a great deal. I mean, the interesting thing about the scheme that was created there is that you can be designated as a group for association with other groups. We have parallel litigation, a case we call Humanitarian Law Project 4, which we talk about on our website, ccrjustice.org/HLP. If you scroll all the way down, you'll see that case, which is, we've gotten a negative panel decision